Hello, my name's Ashley Matthews and I'm an associate in the employment team at Thompson Snell and Passmore. Today I'm joined by Ben Stepney, who's a partner in the team. So Ben, what will we be discussing today?
So today, Ashley, we're going to talk about a very recent Supreme Court case. This concerned the employment status of part-time football referees. The Supreme Court had to decide whether they had the status of employees for tax purposes, or whether, as the referees contended, they were self-employed. The referees and their employer, the Professional Games Match Officials Limited, or POGMOL, argued that they were self-employed and so tax should not be deducted at source. The HMRC argued that they were in fact employees and so tax should have been deducted at source. Most of these referees were part-timers. They refereed in League 1 and League 2 and they had other full-time employment.
So how does this case impact on businesses who are not involved in professional sports?
Well, it serves as a reminder of the distinction between somebody having the status of employee and status of self-employed. For somebody who's an employee, tax and national insurance should be deducted at source by their employer. Employees are also entitled to the full range of employment rights, such as the right to paid holiday, the right to be paid at least the minimum wage, the protection from discrimination, redundancy payments and protection from unfair dismissal, to name just a few. Whereas somebody who's self-employed, they are paid gross and have very few employment rights. Really, the only protection they have is protection from discrimination. It's also important to remember that the label the parties give to an arrangement is not determinative and in fact has very little influence on courts or HMRC as to whether somebody's truly self-employed or in fact have the status of an employee.
So what will the HMRC or an employment tribunal consider when determining someone's employment status?
So there's no exhaustive list, but traditionally over the last 50 years or so, if you look at the cases, there are three key factors that are always taken into account. That is what we call mutuality of obligation, the amount of control exercised by the employer or engager, and the obligation on the individual to provide personal service, as in they have to do the work themselves rather than somebody else on their behalf. This case in particular focused on mutuality of obligation, by which we mean the obligation on the engager or employer to provide work and the obligation on the individual to carry out that work. The referees said that they can choose to officiate as many or as fewer matches each season as they wanted to, and they would generally sign up about a week in advance to the matches they wanted to officiate. They could even change their mind and withdraw on the morning of the match without any penalty or repercussions. HMRC argued that once they agreed to officiate a match, there was a binding contract to provide work and for the work to be carried out, and that pointed towards mutuality of obligation and employee status. HMRC said, and the Supreme Court largely agreed with them, that once they accepted the work and turned up at the ground on match day, they were effectively engaged and working until they submitted their match report a day or two later.
So what did the Supreme Court decide?
Well, in short, the Supreme Court decided that it agreed with HMRC that whenever there's an agreement to provide work and carry out work, there's always mutuality of obligation, even if in between the work or assignments there was no obligation on the parties to provide work or carry out any work or a minimum amount of work.
So what does this mean for employers?
Well, what it shows is just how hard it is to confidently determine somebody's status as an employee or self-employed where they don't have traditional, say, 9-to-5 employment arrangements. We recommend that employers regularly audit their workforce to consider the likes of casual workers, consultants, contractors, to consider whether those who are labelled as self-employed, whether that would stand up to scrutiny if ever challenged by HMRC or employment tribunals. In particular, we see arrangements that are described in contracts as casual arrangements or ad hoc arrangements. But if over time a pattern is developed where the individual's always carrying out a similar amount of work and always accepts it, then you could be moving from the self-employed side of things onto an employment side of things, which brings with it the obligation to deduct tax at source and means the individual can obtain certain employment rights. It's also important to know that even if the individual's happy to have been self-employed and taken the benefits of it over some time, This has very little influence on a tribunal if they later turn around and say, well, actually, I had employee status and I should have been given, for example, paid holiday throughout my time.
So how can our team help with this issue?
Well, we can help businesses to audit their workforce and to try to identify where there may be some risk of self-employed individuals being deemed to have employee status by employment tribunals or HMRC. We can help with audits, we can help with checklists, and we can advise on what factors will be taken into account in determining employee status, and we can help businesses put into place mitigating actions where the risk is deemed to be too high to continue with. It's something that we have been providing for a number of years, and we can also take into account off-payroll working or IR35 rules as well, where your business is big enough to be caught by those rules.
That was really interesting. Thank you so much, Ben. And thank you to everyone for listening. Please do not hesitate to reach out if you would like any advice on this issue from our team. Thanks very much.